All right, well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Thank you for joining me today. I am going to be talking today about probate and trust settlement and kind of the differences between those two things. So if you don't know what either of those phrases mean that I just said, those terms mean, it's what happens after somebody passes away. So after a loved one passes away, depending on their estate plan, what process are they going to use? What process is their estate going to use? What do you have to do if you're in charge of that estate? So we'll go into detail on that. But just a couple quick items. You'll receive from us after this seminar is over a handout, or kind of what goes through probate, what goes outside of probate for asset transfers, for example. It's a pretty helpful tool, just a nice visual tool to use. And you'll also receive a form from us where if you would like to, if anything we talk about today raises concerns for you, or you have a loved one that has passed away and you don't want to administer that estate without guidance, there's a form that we'll send you that will give you a place to fill out whether you'd like us to reach out to you to set up a time to come in and talk to one of our attorneys. We do offer complimentary initial consultations, so there's no charge to come in and talk to us initially. They're set up for about 2 hours, give or take, for initial consultations, just to give time to really get to know the situation. We ask a lot of questions about the family, things like that, and ask for a lot of information. And then at the end of that meeting, we can give you an idea of cost and what we would recommend. So if you would like to do that, you'll have a place to fill that out after this is over. Another quick couple of things. Next week is our public seminar at the Neville Public Museum in Green Bay. So that's where we talk in depth about wills, trusts, powers of attorney, long-term care planning. And if you want to sign up for that, you can go to estateplanninggreenbay.com, I believe. Yep, estateplanninggreenbay.com. I sometimes have to remind myself. And that'll give you a place to sign up for a spot. Sometimes seating can be limited. So just if you're interested in attending, please feel free to sign up for that. And there are 2 sessions for that, by the way, 2 p.m. into 6 p.m. And then our next topic, next webinar the week after that is maintaining control of care at home. So a really common concern for our clients is, well, how do I stay home the longest where I can get the right care so I don't have to go to a long-term care facility right away? And so that topic is going to be about, how do we set that up for that, to work? What kind of things do you need in place? What type of pre-planning do you want to do to make sure that that's feasible for you? And potentially, what are some concerns that you might want to be aware of versus, with at-home care versus skilled nursing, and like when is it the right time for you to do either of those things? Okay, so back to our topic at hand here. And one last thing, if you do have any questions during this, you can submit them to the Q&A and I'll see them come up. So please feel free to submit those and I will answer them as they come up. But probate, trust settlement are, one of 2 processes that you'll use after a loved one passes away, if you're the one handling the estate. So you may be familiar with the term executor. In Wisconsin, that position is called a personal representative. So it's the same exact thing. So if I use personal representative, that I'm talking about an executor, it's the exact same thing. So with probate, somebody's estate would go through probate if they don't have any beneficiary designations on things. If, so very commonly it's the home, which doesn't have a transfer on death designation on it, is one of the biggest assets to go through probate. But in theory, any other asset without a beneficiary designation, would have to go through probate as well after someone passes away. Now, or things without joint ownership too. But when you have a will, what you're telling people about your estate is that you are anticipating using probate. So one of the most common points of confusion for people is, well, if I have a will, they think if I have a will, I won't go through probate. But all wills are actually instructions to the probate process. Who do you want in charge of the estate? How do you want things divided up? What rules do you want people to follow? The only place they have any sort of control is in probate. So having a will does not help you avoid probate at all. And that's not necessarily a bad thing if you have good planning in that will. One of the most common concerns we run into with probate, or when somebody has a will, is that they have that will, but then they have beneficiary designations on everything, a payable on death or a transfer on death on their IRA, on a bank account, on a life insurance policy, right? They have it on all of those things. When you have beneficiary designations on things, what that is essentially is an agreement with the company that when you pass away, it goes from point A to point B. So it goes from you to whoever the beneficiary is without the use of probate. It goes directly to where you've designated it. And that sounds great if you want to avoid probate. But the problem with that by itself is if all of your planning that you have is in your will, well, if wills only direct probate assets, all of that planning in your will is useless to you if nothing you have goes through probate. So a very, very common problem I see, or just sort of a gap in planning rather, is somebody comes in with a will, they've had it for however many years maybe, or maybe it's brand new, but you look at their actual assets and maybe nothing would ever end up using that will. This is a really big concern when that will does something specifically like plan for a child with supplemental needs, right? Somebody who might be on means tested benefits, or you're trying to protect a beneficiary from things like substance abuse or divorce or lawsuits, trying to protect them from those things. Wills can have provisions in them that say if a beneficiary meets any of these sorts of scenarios or situations that the personal representative is concerned about them just inheriting money without those protections, the will have terms to deal with that and protect those, the beneficiary from the liabilities that could be out there for them, or from themselves if it's a responsibility or a substance abuse concern, right? But if you have all of that nice planning in your will, but then you have nothing follow the terms of that will because you've avoided probate entirely, then none of that planning takes place. None of it gets enforced because there's just no way to do that. Wills only direct the assets that are going through probate. So this comes up as a concern quite a bit, especially when there's very specific planning in that will that must be followed, or else it will cause problems for that beneficiary. So it's really important to work with somebody who can help you determine how to make that will effective. How do you direct those assets? And not just, have the LegalZoom will and then try to do it on your own, because it can be very confusing if you don't know what you're looking for and how to direct those assets properly. So you want guidance on that. But the biggest problem with, probably the most common problem rather, that we run into when people have wills but then have nothing go through probate is one of bill paying, right? Or of making sure that their wishes are followed in terms of equal distribution of things. If you're acting as a personal representative of the estate, it's your job to make sure that the bills get paid, the creditors receive notice, right? That the assets of the estate are used to pay those debts, and to divide things up equally. You have to follow the terms of the will. But the most common issue is one where the personal representative is nominated by the court, or is appointed by the court rather, nominated by the will. But all of the financial assets have already gone out to the beneficiaries. And now maybe that personal representative is also a beneficiary, so they'll have access to some funds, but you want that personal representative to be able to pay the bills, pay the expenses out of the funds before they go out to the beneficiaries. There's a couple really big reasons for this. One, once that money goes out to those beneficiaries, it's theirs and they don't have to give it back to the estate to pay out, to pay those expenses. So it can put the personal representative in a position where they're either asking for money back from beneficiaries so that the bills can be paid, or if they're also a beneficiary, they're also using their own funds, maybe their own inheritance, to pay those bills. And there's no real guarantee that they'll be paid back, especially if there isn't any money left over after the creditors are paid. So what you want is there to be a source of funds for that personal representative in the estate to pay those expenses first. Another sort of other side of that is also a common issue is somebody will maybe leave certain assets directly, the bill payable on death, directly to the person that they expect to be their personal representative or executor. This can create its own issues too. It does give them a source of funds to use, of course, But once that money goes to them, that is their money. It's not money that they have to distribute to other people. It's not money that they have to follow your wishes with and give out to the other beneficiaries. So they're under no obligation to do that because they're the beneficiary. It's their money at that point. So it can be really risky to expect everything to go according to plan when somebody doesn't actually have to follow the plan or may not understand the plan or the wishes. Now, more often than not, though, the biggest issue with that is one of whether or not that personal representative can transfer the money in accordance with your wishes. So let's say that personal representative, they're named as a beneficiary, but when they have to go administer the estate, they're in the middle of a bankruptcy personally, right? Well, no bankruptcy court is going to let them use money they've received as a beneficiary to follow the wishes of someone else, right? It's subject to their creditors at that point. Maybe they're in a nursing home and are concerned about needing Medicaid in the near future. Well, if they try to follow and honor someone's wishes by giving out those assets, they're making gifts, which can be a divestment penalty for Medicaid and may limit their options for care down the road too. So what you want them to do is use estate assets to do those things. You want your money to actually use the will if that is your main controlling document. Now, because wills go through probate and beneficiary designations don't, some people still want to find a way to avoid probate and allocate those assets properly and make sure that all the contingency planning is still there, that people can be protected, that their wishes are followed, right? So if that's the goal and probate avoidance is the goal, it's still better to use a trust to do that than it is to use beneficiary designations without any other planning, because trusts do not go through probate. They are outside of the scope of that probate process. They pass things, to the beneficiaries in there. But what they also do is they're sort of like a will and beneficiary designations mixed together, right? They give the trustee in that circumstance the ability to pay expenses out of the pooled source of funds first. So they have access to those things. They can pay the bills they need to pay before everybody gets their share. And then they also make sure that that trustee has an obligation to follow that person's wishes. So it can still be way safer to use a trust to avoid probate, or it still is way safer rather, not that it can be, it is, to use a trust than to just use beneficiary designations. Beneficiary designations, they seem easy. You just put it on the account, fill out the form that the company has. They seem very easy. And in a perfect world where nothing goes wrong and everything goes according, to your wishes and nobody fights, that you can sort of see the future in that crystal ball, there are situations where maybe somebody didn't personally run into issues using them. But you can't plan for things with beneficiary designations. They don't account for the unknown. They only account for where you want things to go initially. So beneficiary designations do avoid probate. They go outside of the probate process. But if you also want to protect those beneficiaries from lawsuit liabilities, divorce, substance abuse concerns, creditors, whatever it is, you still want to use a trust as opposed to using that beneficiary designation by itself. I always look at the beneficiary designations as tools, right? They're not, it'd be sort of like saying, well, I have this screwdriver, therefore I can build a house. Well, you have one part of that process, right? It's not the entire process. It doesn't cover everything you're going to need. And it certainly doesn't help you if that house starts to collapse on you and all you have is a screwdriver. So they're tools to use as part of a process, but they are not a plan. Even when you have all of the beneficiary designations, they're all the same across the board. They have all your wishes honored, in them to where you want things to go. They still can't possibly account for things like if, you would want somebody other than their kids to inherit if they were to pass away, or if you're trying to provide asset protection or, provide some sort of restriction on use, right? They don't provide those opportunities. They're really just transfer from point A to point B. We use them all the time as parts of our, will plans or parts of our trust-based plans, but we are not using them by themselves. yeah, I mean, that would just not account for a lot of things that we may need. It's very important too, if you have a trust, that you actually know how that is going to control your assets. So just like a will only directs probate assets, a trust is only going to control the assets that it actually owns, whether it's during your lifetime or at death. It doesn't control things outside of that trust. So again, with beneficiary designations, with title changes on things, it's very important to work with somebody who can help you title things properly in the name of your trust, if that's, if it's something that you're putting into that trust, or at the very least, help you coordinate those beneficiary designations, that payable or transfer on death, so that they use your trust when you pass away. It's very, very important that you coordinate your assets with your actual estate planning documents. I think sometimes people have a false sense of security by, I have a will, therefore it's going to do what I want it to do. Not without making sure other things are in place first, like making sure that if you're using a will, you know that you're going through probate and that you're allocating the assets properly to that process, right? Same thing with a trust. It's just having a trust but not having anything in it isn't necessarily going to help you either, because you don't have any guarantee that your trust will actually control those assets. Now, when people have revocable trusts in particular, they often have what's called a pour-over will, which says, hey, if something goes through probate, take those probate assets and put it back into my trust. It's kind of like taking a pitcher and pouring it back over, right? But again, that only covers probate-based assets. So there are two big misconceptions with pour-over wills that people have in relation to probate avoidance. I've seen some firms say things like, if you have a pour-over will, it'll help you avoid probate. Well, the problem with that is pour-over wills, because they are wills, only actually direct assets through the probate process. So a pour-over will does not help you avoid probate. All it does is it takes probate assets and puts them back into the trust where they were supposed to be originally. So don't think that, you don't need to fund your trust because the pour-over will do that. Well, maybe, because if you have things beneficiary designated directly to other people and you're not using the will, those won't use the will then because they're not funneling through that will, or through the trust rather, but they also won't use the will and pour it back into the trust because they're not going through probate then. Nobody is expected, if you don't do this on a regular basis, to know how to do this on your own. I've had to, work with clients for a long time to help make sure things are done. Our staff does a really good job with that as well. But when people don't have that help, they very often run into roadblocks or issues where a company doesn't want to, change it the way they want it to, or we're told to change it, or they get confused because they've gotten rejections on certain title changes maybe, or have run into issues and they give up because it's difficult and it takes a lot of time. And I don't blame anyone for that. But what that means is that their estate plan may not actually control the assets they have. So always try to work with somebody who can help you do that, because if they do this for a living, if they, primarily focus on estate planning, elder law, those sorts of areas, they can help you title things properly. They can help give you the proper way of doing those things and make sure that it actually gets done, so that if they're drafting that estate plan for you, if they're putting it in place, they can help make sure that it happens the way it's supposed to. And not everyone does that. Not everyone has the staff to do that, of course, too. But it's very important to make sure that your plan is properly funded by the assets that you have, or that they're properly designated. If probate avoidance is a goal, don't think that your will is going to cover that by itself, because it only directs probate assets, but also rely on more than just beneficiary designations, because that also doesn't account for the unforeseen circumstances I mentioned. Things may go perfectly according to plan, and nobody runs into any issues. But as an attorney, I'm not ever willing to bet on that, certainly. And you also just want that insurance or assurance that things will go to the people you want it to go to and won't cause them any problems when that happens, which is things that both a will and a trust can do for you. but you need to properly allocate those assets then. So expenses, I mentioned a little bit being paid. Really the big concern about payments of expenses with beneficiary designations is just making sure things go according to plan. I sort of talked about whether they have to, spread out the assets according to your wishes, which in my experience, most people want to be able to do. I don't work with too many people who say, no, it's mine, I'm going to take it. I'm sure those people exist, but it's not my experience where that's common. The bigger issue is whether they are able to make that gift, whether they're able to allocate those assets, or if they have liabilities of their own that are causing problems. To give you, an example of what can happen if they don't have a plan in place, somebody doesn't have a plan in place, there are a lot of times issues with things like somebody transferred the home over to the kids well before they themselves passed away, whether that was to transfer it during lifetime for some reason, maybe Medicaid planning was a concern. There could be a lot of different reasons that somebody would want to do that, I suppose. But they don't account for things by doing that, like things like tax planning, or if one of the kids passes before them, it doesn't direct it beyond that point. Or what happens if one of those kids has a liability of their own. There's no contingency planning in place with just transferring assets, whether that's through a beneficiary designation or just through a title change directly to the beneficiaries. You need something else in place too. You need those assets controlled by a will or a trust. So to give you an idea on the probate process, just because I've talked at length about the difference between the two, but the probate process, how it starts if you're that personal representative, the will be filed with the court, in the county where that person was a resident, right? The will will be filed. The personal representative doesn't immediately have access to things. They still have to wait to be approved by the court. So when you put in your will that you have, I want John Smith to be my personal representative, that's not a guaranteed thing. Now, the court takes that heavily into consideration and will almost certainly, barring some sort of revelation that they're, a chronic fraudster, right? Something like that. Or they have a history of financial abuse, or whatever it is. Barring those sorts of situations, they're generally approved. But it can take some time. It takes about a month I guess on the short end of things, just because people have to be given notice. It's not immediate. They have to give notice to the beneficiaries to make sure that they don't object to this person being appointed. And if there are objections, it can take even longer than that month. Now, once they're approved though, then what happens is that at that point, that personal representative has the ability to set up a state account, start paying bills, start giving notice to creditors, right? But until they are approved by the court, they receive domiciliary letters is what they're called. They have no proof that they can act on behalf of the estate. So what that means financially is with probate, temporarily, probate assets are going to be frozen. Nobody's going to have access to them right away until that person's approved. That sounds a lot scarier than it actually is. A lot of places understand, most creditors, after they receive notice that someone's passed, know that they're not going to get paid right away. They know that there's things they have to wait for, proper channels. And if they don't know that and start to harass the personal representative, well, they can be told to stop because they're not following the proper channels either. So it sounds scarier than a lot of people think when it's, oh, what do you mean my bills won't be able to be paid right away? Well, not within that first couple of weeks maybe, but it doesn't mean that they will never be paid. It doesn't mean that no one's ever going to have access or that it's going to be an extended period of time. But again, that can still be a concern for some people. They want bills paid more immediately or want someone to have access right away to cover miscellaneous expenses. This can be a bigger concern too if somebody is like taking care of a disabled adult child, where a continued payment of those expenses is important, right? That can be a concern for some people. So in that circumstance, probate with certain assets being frozen in the meantime might not be the right tool for that concern. It just depends. But the creditors have to be given notice, as I mentioned. For probate, that's a 90-day roughly period of time. So what you have to do is the first of those 90-day period, you give a public notice to the unknown creditors and direct notice to known creditors. then you do it once a month for 3 months. And at the end of that 90 days, if somebody hasn't come forward, their claims are barred, right? They can't come forward a year and a half later and say, well, hey, we have this bill, we just forgot to forgot to file a claim against the estate. I've actually had that happen where somebody found found the direct notice that was given to them. I think it was a hospital. They found it, 8 months later, just because it was buried under paperwork on their desk. And the court said, I'm sorry, you're way past your period of time there. So it can be beneficial to the estate too, to wait to pay bills until all that notice is given and people file that claim. After those bills are paid, after the inventory is all filed, inventory meaning just what does the estate have in terms of assets and items, that's when the personal representative will follow the will make sure that they have, everything accounted for, that everybody gets their fair share, that the expenses are paid, right? That if they need to protect something that the will allows them to protect, they can do so. Probate on average is about a year to a year and a half process from start to finish, just to give you an idea. And the cost to the estate varies. It's going to depend on attorney's fees, on whether there's a lot of complexity or whether it takes longer than that year and a half. But generally speaking, you see anywhere between like 3 to 5% is the number you'll hear a lot. So to give you an idea, probate for $1 million estate would be, a $30,000 affair, potentially. Which is not inexpensive, obviously. Now, trust administration works a little bit differently. It can be a little less formal for the family. So if somebody, instead of being that personal representative, is named as the successor trustee, once they are acting, once both of the parents have passed or the surviving parents has passed, they're automatically the trustee. There's no court approval for that. So the assets aren't frozen temporarily. That person is able to act relatively immediately. Not like necessarily immediately. We still have to have them sign certain documents, but it's not that month, on the short end of things. Nobody has to approve them either. It's just they've already been chosen. In terms of creditor notice for trust, it's a little longer than probate. It's about 120 days roughly. And that's really because trusts are more private. So they want to make sure that people have plenty of notice to come forward if they're unaware of like a public notice from probate, for example. But trust administration overall, like when somebody is dealing with somebody's estate through a trust, that generally is 6 to, I shouldn't say 6 months, that'd be pretty quick. 8 months to a year is pretty standard. So it's still not immediate, right? It's still going to take some time, but that's because you need to make sure things are done properly. It pays to make sure things are done properly because you don't want somebody coming back later to you as trustee or as personal representative and saying, we didn't get the notice we were supposed to, you didn't do this properly, right? That could be bad. You want to make sure that you have followed all of those proper channels and followed the steps, which is again, where it can be very helpful to work with a professional on this and not try to do it on your own. Some estates are different, but for the most part, people tend to be better off having some help with it. But with trust administration, costs tend to be lower too. And this is primarily driven by the attorney's fees difference, honestly. And that's just because it's less work on the attorney side to help someone administer a trust than it is to deal with probate. Probate is a much more involved process than a trust administration, potentially, especially when you have courts requiring certain things or setting deadlines for certain things, right? It's much more rigorous in structure. It's not very flexible, right? So trust administration, though, you're generally looking at maybe a % or 2%, depending on attorney's fees. So a little bit less, but when you're talking about that $1 million estate I used as an example, which is not all that uncommon these days, it's a potentially $20,000, $40,000 difference, depending on where you fall in that range. So it could be a huge, huge savings to the estate. And trust administration tends to be a little bit more efficient for people too, in terms of getting things done quickly. Easier for them to deal with because there's not that court mandated time frame on everything. So it can make it a little simpler. But that being said, there can be plenty of reasons over using trust administration too. And I'm not to oversimplify the two processes. And it looks like I'm running out of time and I don't see any questions. So I know this is a really in-depth topic too, so we'll talk a lot about wills and trusts next week at the Green Bay Public Seminar at the Neville Museum. So if you're interested in hearing more about those two things, please sign up for that at estateplanningreenbay.com and Medicaid topics as well. And then again, keep an eye out for that feedback form where you can let us know if you'd like to sign up for that initial consultation, which again is complimentary. And you'll also receive, like I said, our handout on our sort of flow chart on what goes through probate and what avoids probate, which can just be a helpful summary for you. So thank you all for joining me, and I hope to see you guys at the Green Bay Public Seminar next week. But otherwise, enjoy the rest of your day.